Hello, 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 beautiful people. Welcome back. Besides the acting judge being an issue in most people's case, lawyers are also one of those devils. You want to know a very easy way to rule out a lawyer in a situation based on this thing called conflict of interest? On the Patreon page, we show exactly how to invoke conflict of interest when it comes to the intent and the role of an acting judge relating to the intent and the role of an attorney. On YouTube, we'll show another way, and that is by simply making the lawyer a witness. When that lawyer or attorney comes into the issue, the only thing that they're doing is bearing witness to what you write and hoping that they can say something that qualifies an exception to a hearsay rule. Outside of that, all they're doing is just running their mouth, talking a bunch of trash. It is now your responsibility to put them into the proper position for the purpose of disqualifying them. For instance, with interrogatories, the reason why you do interrogatories is to follow up a disqualification. Not just to do it just for the heck of doing it as part of discovery. The way that you disqualify a lawyer based on conflict of interest is vast. And those different means and its varying degrees is based on the roles that are being played. That's why the concept of conflict of interest exists. It's based on the role. Then if you're in a game and you say you're a midfielder in a football game, international football, you cannot be a midfielder and also be a goalie, because goalies can use their hands and feet, but a midfielder or a striker or any other position cannot use their hands. Thus, there's a conflict of interest in the role being played, and you get to be disqualified. Same applies on pen and paper. One way, again, disqualify an acting judge or an attorney is to show the conflict of interest relating to the acting judge and the attorney, which will prejudice you. If you're attacking the acting judge using the relationship between the attorney and the judge, and the relationship doesn't have to be some friend relationship. It can be simply based on the fact that they're both lawyers. But there's a way you're going to show that, and there's a proof based on that on a national and international level. We go over that on Patreon. But you can use that means to attack the acting judge, or use that means to attack the attorney. But here's another way to which you can show conflict of interest, but more specific to the acting attorney. Since they're already playing a role of trying to act like a witness, but they're not formally titled into the case as a witness, you can make them in a witness. You can turn them into a witness, and by virtue of that, prejudice the interest of the case itself, because they cannot play the role of a witness and the role of an advocate. Whenever attorneys come into a situation, they're not coming in as a real party of interest. They're not coming in as anyone with first-hand knowledge and experience, and they don't claim to be those things. The role that they're playing is an advocate, meaning I'm speaking up on behalf of this man or woman, aka a counsel. But a counsel cannot also be a witness, aka an advocate cannot also be a witness. Did you know there are actually rules against that, which you will use as a step to disqualify an attorney? These are the reasons why you must pay attention to these rules that everyone tells you to run away from. And even though these rules that I'm about to show is on a state level, guess what? It is uniform on each state. For Illinois, it's Rule 3.7. In Massachusetts, it's also Rule 3.7. For North Dakota, it's also Rule 3.7. For California, it's also Rule 3.7. Lawyer is a witness. Lawyer is a witness. Lawyer is a witness. Lawyer as a witness. And the verbiage to each of them reads extremely the same because they're founded on the same principle. So how exactly do you do it and why? Let's go into that. A lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness, unless, and then they're letting you know that unless these three things exist, then a lawyer cannot be a witness or an advocate, meaning they cannot speak on behalf of another party. In other words, what you're going to do is, usually if you see that the case cannot be dismissed using the equitable relief called a motion to dismiss before the trial, because if you're really right and you are really not guilty, you don't have a guilty mind, then most of your case will qualify to be thrown out before trial. The only reason why a trial is triggered is to try the sufficiency of the facts stated in the complaint, because there's still some dispute linger, and it's not been shown beyond a reasonable doubt in criminal case or by preponderance of evidence in civil case that no need to try the sufficiency through trial. And the way it's done through trial is to look at everything you've put in thus far and to now formally adjudicate upon it, and to go through the question and answers of things on the spot or otherwise. And the looking at all the documents before the trial stages includes something called list of witness. Before trial, you will put in the list of exhibits you need or intend, and you put in a list of witness that you intend to call, either through direct examination or cross-examination. Direct examination is a witness that you called upon yourself. A cross-examination is a witness that your opponent is using to their favor, but then you're holding that same opponent's witness as yours. So when you put your witness list in before trial, guess one of the parties that you will place on that witness list? The opposing lawyer. Why do you want to do that? You want to do that because a lawyer shall not act as an advocate, meaning they're speaking on behalf of the other party against you. That's what they're doing as an advocate. When you add them as a witness in your witness list of people that you'll be holding as witness for direct or cross-examination, you've set them up for disqualification. A lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness, unless, meaning so long as these three things don't exist, unless the testimony relates to an uncontested issue. Obviously, everything the attorney is going to be saying, you're not going to leave it uncontested. And two, in other words, if you've acquiesced to what they're saying, then they can act as a witness, which most people do. Two, the testimony relates to the nature and value of legal services rendered in a case. You're not going to be asking them questions regarding to the services that they're providing. You're going to be asking them questions about the issue and the things that are being purported against you. Since they say they know so much about it, well, come in as a witness and speak then. You're not going to be speaking about the service they're providing because there's attorney-client privilege anyway. And you're not going to be acquiescing to everything they say. You would always bring it up through your rebuttals, through your answers, through judicial notices, and through the triggering mechanisms of Trinsley versus Pagliaro, where statement of counsel, whether written or oral, is insufficient for a summary judgment. Summary judgment is just whenever someone wants something to be finalized in a case to their favor. If you acquiesce, and if you're dealing or trying to speak about, well, come and take the witness stand and tell us the type of service you provide, then you cannot call them as a witness. The third exception is disqualification lawyer will work substantial hardship on the client. It's already working a substantial hardship on you since they're coming in talking a bunch of trash as though they're a witness. So now when you put them in their proper place, it will cause you a substantial hardship if they're not called as a witness to clarify their standing and position in the case as to the experience they have, which you would use in para with Trinsley versus Pagliaro. This video is being done to show people that your mere statement or putting in the order of Trinsley versus Pagliaro is not enough. Once you know the triggering mechanism, which we mentioned on Patreon, and once you know how to use judicial notice, this is the next step. This is the third step to using Trinsley versus Pagliaro. You add that acting attorney into your witness list. But in order for you to do that, you must have rebutted everything they mentioned, not acquiesce to whatever trash they're saying. And two, when you begin to bring in papers into the equation regarding their standing capacity and why you're making them a witness, it's not going to involve their legal services. It's going to involve their knowledge and experience of the claim being brought against you, either by the state of so-and-so or by whoever is saying they're suing you. Or even if you're the plaintiff and the defendant hires a lawyer, same thing. And most importantly, you will have to show that is not provide hardship on the one that they're representing, especially if they're working for a firm. When it favors them, they can switch lawyers. Like they're switching between breaths. So if they're working for a firm, then this third part doesn't even play a role at all. And if they're not working for a law firm, aka they call them, quote, private attorneys, then in order for you to trump this hardship against the client by calling them into a witness, which will disqualify them from even being in the case in the first instance, you will have to show the fact that their presence in that case by playing a witness under the guise of being an attorney or a lawyer is a hardship upon you. And that's extremely easy to prove. A lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by Rule 1.7 or 1.9, which is what we just mentioned regarding law firms, since they can switch people around. Now, what is the logic and principle behind this? They tell you, combining the roles of advocate and witness can prejudice the tribunal and the opposing party, and can also involve the conflict of interest between the lawyer and the client. Meaning the moment an attorney acts as a witness in a case, it's automatic prejudice against the proceeding itself. It defeats the intent of justice and abrogates the principles of due process. And it creates a miscarriage of justice. These are the specific languages that you put into your document. In other words, conflict of interest. If you're at Illinois, this is self-authenticated. They have their seal and they have it digitally signed and reported. And guess what? They put an attestation on it based on the rules of authentication. I attest to the accuracy and the integrity of this document. They date it. Then they put their seal. The reporter of decisions is anonymous to like a clerk who writes things down. But in this case, when it comes to the list of what the Supreme Court says as their rules at Illinois. So if you're at Illinois, you don't even need to do a certificate of true and correct copy. It's right there. At Massachusetts, the exact same rule, the exact same title. It says the exact same thing. A lawyer shall not act as advocate at a trial in which the lawyer is likely to be necessary witness. At Illinois, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. Then it gives the exceptions, which is they can actually act as a witness at a trial and still be the lawyer so long as you acquiesce to everything they've said, so long as you bring up the contention of their legal services to which attorney-client privilege covers them, and so long as you fail to show that it will not cause hardship to their client. It says the exact same thing in Illinois, exact same verbiage in Massachusetts, exact same verbiage. At North Dakota, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness, except where the exact same principles. California, same rule, same title, same verbiage, same principles, same intent. So to those that are quick to cry and whine and be lazy, to not do their own research, or with the intent of trying to make something look invalid based on their incompetence, even if it's at one state or the other, the foundational principle, and in many cases, the rule, the citation, the verbiage, the layout, and the format of that specific rule, and the word for word, and even if it's not word for word, the principles will always be the same. Does not matter where you are. And this is just in between states. This is not even a comparison of federal jurisdiction to state, which is usually similar also. Now let's go just a little bit deeper and hear from the horse's mouth. American Bar Association. Rule 3.7, lawyer as a witness. What do they have to say about it? Combining the role of advocate and witness can prejudice the tribunal and the opposing party, and can also involve conflict of interest between the lawyer and the client. At Illinois, they give you a comment based on the intent of how and why they passed it on January 1st, 2010, and said the exact same thing. Combining the role of advocate and witness can prejudice the tribunal, and the opposing party can also involve a conflict of interest between the lawyer and the client. When it says it can prejudice the tribunal, it talks about the presumption that any type of setting whereby there's supposed to be a neutral role of an acting judge, you as a plaintiff or defendant, or another party as a plaintiff or defendant, or the intricacies or formality of the parliamentary rules are involved. If you don't know what the parliamentary rules are, a video on that has been done last year, and on Patreon page we've posted what they are and explained it. But what it means when it says prejudice to tribunal is that there's a presumption that a due process is supposed to occur. There's a presumption that everything that's done in there is not supposed to abrogate due process, aka Constitution. Even if they're tribunal, aka legislative courts, they are still bound by the Constitution. Simple as that. So when people cry and whine, speaking of, oh well, you can't bring up constitutional issue in the lower courts, those are people still lying to themselves. Most of the situations that I've dealt with, I had no need to even escalate it. If you know what you're doing, you will kick their ass in their own venue. They will remove you so quick from that situation, it will be like magic, because they don't want you going in there destroying their nature of business. And if you know how to really twist that knife once it's already been jabbed, I mean, it'll be child's play for you. There'll be a little bit of element of apprehension or excitement, anticipation of fear and things like that, but nonetheless, if you're on point and your spirit game is on point and your mind game, not mind game against someone else, mind game upon yourself, the best one to put any type of magic work or to hypnotize is yourself, not anyone else. If you're on point on that level, it will be very easy, and the constitutional principles will follow you everywhere you go, whether it's an administrative court, colorable court, or not. Stop making excuses. So when it says prejudice the tribunal, the presumption is that due process is supposed to exist. Due process is procedural, substantive, based on the Constitution. Substantive is the verbiage of the Constitution. Procedural are the parliamentary rules, which includes these things that we're reading right here, right now, that we're explaining, to which your remedy is in when you put in your witness list and add that opposing attorney as your witness. Why? Because they cannot act as an advocate and as a witness, because it will prejudice tribunal, which brings us back in a full circle. What does it mean to prejudice the tribunal? It prejudices the tribunal because due process is supposed to exist, and the whole purpose of that venue is in fact to not create a miscarriage of justice. It's like pregnancy. The pregnancy is the outcome of what the substantive law says. If a miscarriage of that outcome of what the substantive law says occurs, then the tribunal itself is prejudiced, meaning the intent of its creation crumbles, and thus they have no power when they violate the Constitution. And so that the precedent itself does not become unconstitutional, they have no choice but to disqualify that lawyer the moment you add them as a witness list. Once you add them as a witness list and they are stupid enough to not recuse themselves as an acting attorney, then you move for impeachment. That's another thing people don't talk about. They talk about do discovery. If you do discovery and they don't see anything, they can't move on. Okay, well, what do you do after that? Do you just wait? Because the acting judge is not going to assist you and tell you. They might shoot you clue here and there in their court orders if you're on federal level or through their minutes. But do you even have eyes to see it? It's the question you ought to ask yourself. You move to impeach them. Just like you move to impeach a witness or a juror, or you move to substitute or recuse an acting judge. You do the exact same thing when they're an attorney. That is when the substance of Trinsley versus Pagliaro comes in. You see? That's how you do it. Now let's hear from the horse's mouth. Combining the roles of advocate and witness can prejudice the tribunal and the opposing party, and can also involve conflict of interest between the lawyer and client. Why does the attorney who's representing the client, why does them playing a witness create a conflict of interest to the client? Well, they don't have first-hand knowledge and experience of what the client says. So now when they begin to act as a witness, automatically, that is a conflict of interest by operation of law, aka ipso jure. Not ipso facto, but ipso jure. Advocate witness role. The tribunal has proper objection when the trier of fact, aka the acting judge, may be confused. So for all of you who are going on about Administrative Procedure Act, administrative courts, this and that, these basics can still be used because it's applicable. In fact, it is designed to be used therein. Again, if you let competence precede what you're doing, all these stuff people are throwing around to say, oh, that's the excuse, they would always act as fraud, it's administrative court, say that you don't consent. You can say that you don't consent to administrative court all you want. The fact that you're putting in that paper to say, I'm not consenting to administrative court, or I'm doing special appearance, whatever it is people do, that's called a pleading. You submit to the court's jurisdiction through pleading. At least that's one of the ways. So the moment you put that in and of itself, if you're not formally removing and doing a counterclaim, or if you're not doing something like a constitutional challenge, and you just put it in and say, I deny that I'm part of this administrative court, or I'm doing a notice of special appearance, you're dabbling in it. They're going to ignore it and railroad you. If you really say to the administrative court, aka it's a tribunal, aka it's an Article 1 court, which, by the way, Article 1 court is not the piece of paper or the physical building. The tribunal is not the piece of paper or the physical building. We go over that on Patreon. All these buzzwords people throw around, know what it is you are dealing with. The tribunal has proper objection when the trier of fact, aka the acting judge, may be confused or misled by a lawyer serving as both advocate and a witness. Meaning the presumption is that whoever is acting as an advocate on behalf of any given party, aka an attorney or lawyer, cannot also be the witness. And this is the reason why statement of counsel is insufficient, whether written or oral, for summary judgment. When you read that Trinsley versus Pagliaro case, the reason why that came up is because the attorney did not have any material evidence in the case to back up what they're trying to do, which was summary judgment. And most importantly, the issue of them acting as a witness was also brought up somewhere along the line during the early stages in that case. That's how that verbiage, statement of counsel, is insufficient for summary judgment, whether oral or written, within that Trinsley versus Pagliaro. So don't just take that little phrase or that case law because you heard it somewhere and you run away with it. Know why it exists and how, and the functionality of it. We're showing and explaining it herein. The tribunal has proper objection when the trier of fact may be confused or misled by a lawyer serving as both advocate or witness. The opposing party has proper objection, usually you have proper objection, where the combination of roles may prejudice that party's right in the litigation. Wherever your right is prejudiced, remember one of the exceptions as to why and how they can get away with playing the role of an advocate, aka a lawyer, aka attorney, and also the role of a witness, is if it only prejudices their client, meaning the opposing end. Remember earlier when I said the way that you can override this is to show the hardship to you? Well, right from the horse's mouth, American Bar Association tells you the opposing party, which is usually you, has proper objection, which is one of the things that you have to do. You have to object. If you don't object to it, aka if you don't contest to it, it becomes an exception to where they can play witness and an advocate. So do you see everything playing out in dynamics right now? The opposing party has proper objection. You have to raise an objection. You have to deny them. And you have to know the 19 types of objection. And if you don't raise the specific one, just rebut them through an answer. And always refer to them as a volunteer. The opposing party has proper objection where the combination of roles may prejudice that party's right. Wherever your right is prejudiced and you have objected to the fact that there cannot be a witness and an advocate, which the opposite of those two things are mentioned as exceptions. If you don't object and if you don't show your hardship. But when you do object and show your hardship, it triggers the fact that there cannot be a witness and an advocate. A witness is required to testify on the basis of personal knowledge. Listen to this. A witness is required to testify on the basis of personal knowledge. Isn't that what a lot of people go on about when they say, oh, well, they can't say this because they don't have firsthand knowledge and experience, so Trinsley versus Pagliaro? That Trinsley versus Pagliaro is not enough. You have to show why and how, and you have to use the dynamics of what triggers it. While an advocate is expected to explain and comment on evidence given by others, meaning what they observe retroactive to the circumstance that gave rise to the case, rather than as a witness. And the only way that they can be expected to explain and comment on evidence given by others is based on what you write on the ongoing instant matter. It may not be clear whether a statement by an advocate witness, aka when they play both roles, should be taken as proof or as analysis of the proof. You don't want to leave this lingering. You want to go through the basic steps of what we explained earlier in the portion of this video of how Trinsley versus Pagliaro is triggered, and bring up the opposite of these three, and then name them as a witness. If they don't automatically disqualify or recuse themselves because they see where you're going, then move to disqualify. If the acting judge rules against you based on the totality of the case and you preserved all those staggered step setups, because that's what you're doing, you're setting them up, you can easily appeal it and win the case. And if you don't appeal it and win the case, you can do other remedies like a mandamus. Or that itself can trigger a new counterclaim, where you will now be suing the acting judge and the attorney personally in their personal capacity. Now sovereign immunity and prosecutorial immunity does not apply. You have to know how all these things link and how you can set them up. No one ever speaks about this. So that's another furtherance of how to disqualify those people coming against you talking a bunch of trash. That's another furtherance in the use of that thing called Trinsley versus Pagliaro. Overall, in summary, we show the uniformity of the exact same intent of this simple tool. Then we explain how to use this tool, because anyone can stumble upon this and read it. Do they know what it leans on and how to use it? 9 out of 10 people who read this would not know how to put it into operation. We explain how to put it into operation. We then show the different states. It has exact verbiage to show that it's the same everywhere. So you cannot make an excuse that, well, I'm in this state, so it's not this. It's the same thing. And then we go straight to the horse's mouth, where they tell you exactly why even they can't do anything. The American Bar Association is just a combination and a conglomerate of people who are attorneys and lawyers who come together for the purpose of making money while acting as a shield, aka the title of an esquire of an entrance of Queen of England. Esquire is an English title whereby the Queen knights someone and gives them a title, like a duke, like a count, like a lord, like a sir. Esquire is a title, and the etymology of it means a shield for the commercial interests of that Queen of England that everyone goes on about. Now that that woman has passed away, what do you think your estate is just going to be given to you and you're going to turn to a millionaire just because you've authenticated the birth certificate and you don't know anything about public offering and taking the matter into your own hands and actually doing it yourself? They have their own trusts, and they will keep televising and publicizing how they're transferring your estate to their own heirs. Well, you think just because someone passes away automatically everything is going to be given to you? You're delusional. What makes you think they don't have their own trust? You're finally figuring out how trust works. What makes you think they haven't figured that out, or that they haven't been using it before you were born? before your great-great-grandparents were born. Be realistic about how these things work. Take your life and these matters of your life into your own hands by being competent and understanding intricacies specific to each venue. And don't try to just throw a blanket in everything. One of them being Trinsley versus Pagliaro. The specific rule explains to you exactly how it's done. And we even explained in deeper detail beyond what you see here in black and white. Until next time, take care. Best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people to make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not. The intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that are on YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the express trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it, based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference and the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. Speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. Speaking about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort, speak about trust, speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight, beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.